Yes, just 1 minute. Janice, you...
Yeah, I just wanted to respond to the question from the Assembly member. I think in the way the bill is drafted, that it does not impact every single nurse practitioner. It only impacts the nurse practitioners that are seeking this certification, and that are so. It only impacts the nurse practitioners that are seeking independent practice. So and I want to make sure that it's clear, because I heard a number of organizations raising concerns, and I believe what they're concerned about is the existing population. So, for example, if you are employed by a hospital and you are happy with your employment at a hospital for all the reasons that employment is a good thing, you're not impacted by the amendment suggested by the committee. But if you are a nurse practitioner at a hospital that is seeking to practice independently, in other words, that's making a conscious decision to make a change, then the corporate bar applies, because you are making a conscious decision to exit physician supervision, to exit the standard procedures and protocols, and enter into independent practice and be the final decision maker for the patient. And we believe that the final decision maker for the patient must have the independence so that they are not being pressured by whether it's the economics of the hospital or whoever the employer may be. And that's why we fundamentally believe that the application of the corporate bar for those nurse practitioners that are seeking to make that transition, it should apply. And so I think to Mr. Mullen's question, does the committee amendments go far enough? We think the other issues should be addressed. We think medical board oversight in the way that we initially presented may not be workable. But we're having that discussion in AB 1306, where we're changing medical oversight to medical involvement. And again, we keep, to Mr. Mullen's point about working out solutions, we are, if the amendments that are with the Senate Business and Professions Committee were in print, we'd be having a fundamental different discussion about CMA's position on 1306. So the notion that there's not a pathway, that there's not the ability to have a discussion, quite honestly, when we had the discussion with the senator's staff, I think their comments were very consistent with his comments now. There are certain things that aren't up for discussion in their view of how this should work. And we respect that. If they don't think that that's the way it should be, in terms of doing the totality of the consumer protections, so that you don't have practitioners, whether they're a primary care physician or a nurse practitioner, who functionally have the same scope of practice, are not playing by two different sets of rules.
All
Quite
right.
honestly, I don't understand why that is an unreasonable request.
Mr. Bloom.
Overall, I think my head is in more or less the same place that Mr. Mullins is. And I guess I'm officially on the fence right now about what to do about this, and I wish there was some way to bring this all together. Sometimes that's not possible. Let me see if I can ask a couple of questions that are specific to the exemptions. Specific to the amendments. With respect to the medical board oversight issue, I'm wondering if both sides can address why the oversight that is proposed in the bill is superior, the same, or inferior.
Well, that is something I would never agree to. The charge of this committee is that to do a sunset review of all the boards and bureaus within the Department of Consumer Affairs. It is the ultimate protection of that particular board of the consumer. If that particular board has a problem, can't get quorums, is not doing its due diligence, it is this committee that has times sunsetted it, not reconstituted, and has literally gotten rid of all the board members and reinstituted board members. So there is a time and a place for every particular entity, and all the professions have had their particular problems. And the role of those board members are to protect not only the consumer, but to take away the license of their licensees and discipline them. So I believe we have a system in place that allows that. It would be, why would you have the fox, go to the chicken coop? I mean, I think it would be very difficult to have integrations of the various professions, and we have a system already in place.
If I can I just speak to that from the nursing community's perspective? Nurse practitioners are licensed by the Board of Registered Nursing. That's who grants their license, disciplines them, investigates complaints. That's their enforcement body. And when complaints come before the BRN about a nurse practitioner, what the board does is they bring in expert reviewers, and those always include physicians. And those expert reviewers look at the case and say, what is the standard of care in the community, and did this nurse practitioner violate it? That process exists. It's a robust process, and we feel like that's an appropriate process that's already in place. And if I could just say one more thing to you and Mr. Mullen, I mean, we appreciate your desire for some incremental movement here. And from the nurse practitioner's perspective, this is a very incremental bill. 20 other states in the District of Columbia, most recently the state of Nebraska, have adopted bills that let nurse practitioners work without physician supervision in all settings, so that are much broader than this. This bill really is a very incremental step forward.
To your question, Mr. Bloom, the request was informed by history. So we submitted a proposal saying we would like medical board oversight, but we said, look, we're flexible on what that looks like. And we were informed by history on that piece, whether it's the dental surgeons that created a credentialing committee, and that credentialing committee had 2 physicians on it, a dentist on it, and a dual MD DDS.
If forgive me for interrupting.
No, sir.
My primary interest here is in trying to understand why one system of oversight is superior or inferior to the other.
Yeah, and so just to finish.
Our primary, at least from my perspective, my primary interest is in protecting the consumer.
So, Assemblyman Bloom, my understanding is currently, if under the way things work now, because nurse practitioners or advanced practice nurses are under supervision or have a protocol, if there's a complaint about the standard of care, the nursing board would look at whether or not that nurse practitioner followed the standard of procedures, followed what was in those procedures and followed them correctly.
But you're talking to me about the mechanics of it.
Okay.
Why will that system not work as well as the medical board?
Because, sorry, let me just back up and be very simple.
I assume that's what your perspective is.
That is completely accurate. Essentially, if you look at the makeup of the nursing board, it's the vast majority, except for one member, my understanding, are registered nurses. Mm-hmm. You're now asking registered nurses to opine on the standard of care for something that exceeds their education and training, because a nurse practitioner and what a nurse practitioner is allowed to do is beyond what a registered nurse is able to do. So yes, while they bring in expert witnesses and things of that nature, the final decision makers on whether or not the appropriate standard of care is met are individuals that by definition are lesser trained than the NP and have a smaller scope of practice than the NP. So the thing that they would be opining on, they aren't trained to do and have never done. And the final decision maker in that regulatory scheme, in our opinion, should be someone who is trained to do the procedures and has the ability to opine on whether that standard has been met. And again, that was informed by history. So it's the same thing that we did in a slightly different fashion with regards to the dental surgeons. And it's also the same thing that we've done with regard to the podiatric board.
And there is in the statute a position, a board member position on the Board of Registered Nursing that is statutorily designated to be an advanced practice nurse. So there is a nurse, we'd love to have more, There's a guarantee that there is at least one on the board, and then again, they bring in expert reviewers, which include physicians when they have a disciplinary case.
So these oversight boards go about their business, obviously, in different ways, but I guess I'm still up in the air as to whether or not one is less effective than the other. I understand the makeup is different, but at the end of the day, we should be looking at outcomes and how we're achieving outcomes. And so I'll continue to think about that. My second question has to do with the medical board, the corporate practice issue. It sounds like doesn't sound like, it was stated that there are some exemptions in the bill, and it sounded like hospitals, or at least most hospitals, nonprofit organizations were exempted. Is that so?
No,
hospitals are not.
Yeah.
So my follow-up question is, why not?
So the exemptions are, to make it easy, the exemptions essentially are public hospitals, so those hospitals that are run essentially by the government, whether it's state or local government.
Why should we treat those differently than all other hospitals?
Because at the end of the day, it's the profit motive, right? So we aren't.
Then
so
why not exempt nonprofit hospitals?
Essentially, not all non-hospitals. The hospitals that are doing charity care are exempted, meaning that they're not charging the patients for that which they receive. So that version of nonprofits are exempted. But the grander sort of tax-exempt status, which you can hit tax-exempt status for a variety of reasons, and I'm not a tax expert. I'm not going to sit here and suggest that I am. But I believe the argument is there is still a profit motive, even within those that aren't, that in between. They're nonprofits, but they're not charity care.
If I may.
Proponents want to take a stab at that?
Jackie Garman from the California Hospital Association. There are 433 licensed hospitals in California. The exemptions that exist for hospitals under the physician corporate practice ban apply to 41 hospitals, less than 10% of California's hospitals, which have approximately 13% of the beds. So the vast majority, approximately 90% of California's hospitals, are not subject to exemptions from the corporate practice ban, and thus would be prohibited under the ban that's proposed here from hiring the nurse practitioners covered by the bill. Or continuing to employ them. So, and by our best estimate, there are approximately 19,000 nurse practitioners in California, and approximately 25 to 30% of them are employed by hospitals.
So is there an argument to be made for exempting, including a provision on corporate practice, but exempting all hospitals from it?
There is certainly such an argument to be made because of the 50 states and the District of Columbia. The vast majority of them do not have a corporate ban applicable to physicians at all, or exempt hospitals, or at a minimum nonprofit hospitals. So clearly, most jurisdictions in the United States have found it acceptable in terms of protecting the quality of care in order to permit their employment by hospitals.
So was that something that was discussed as a possible compromise?
Mr. Bloom, if I can ask you've got a witness that wants to address your question, I think, real quick.
That'd be fine.
Ms. Hicks, if you can make it quick, please.
Sure. To answer your question about whether, specifically about whether that was proposed, I think that the issue is not about the corporate bar as it exists today and what should or shouldn't be exempted or what is good or bad. We are willing to have that conversation, but the issue is what physicians the safety component, patient safety components that the law exists today that physicians adhere to, we think anybody that's practicing medicine needs to adhere to those same things. So if we were going to exempt hospitals or nonprofits or go down that road, that's a much broader conversation, because it would be whether we're exempting them for physicians as well, which is another bill in its entirety that would get all sorts of contentious things in this committee, but we can address that because that's just a different issue. Right now, what exists today, we want to have the same things exist for anyone that's practicing medicine.
I think that's been clearly stated a couple of times.
Thank you all.
Mr. Bloom, I can move on?
Yes.
Okay. Dr. Wood?
Yes, thank you. This is a tough bill. It's a really tough bill. There are 3 legislators in the room here that represent rural areas, and that's absolutely a critical part of my concern here. I deeply value the role of nurse practitioners. I think they're a really critical part of our healthcare system. You know, in my area, as we lose, not gain, as we lose primary care physicians, we are losing the oversight that allows those nurse practitioners to practice, and that is a double hit in some of my rural areas. I'm concerned about the oversight issue, quite frankly. I would actually be happier with some sort of a ban of the corporate bar in rural areas as an incentive to get people to practice where we need them. I lived through the expansion of independent practice for dental hygiene on the grounds that it would be that it would increase access to care. The reality is 10 plus years later, we really haven't seen that. We've seen in a very, very limited basis. I believe that if this is passed, and that the number of nurse practitioners who will actually take advantage of this will actually be fairly small, because the reality of an independent practice is a challenging animal, and the reality is, as we transition in healthcare to a more integrated system, independent solo type practices are going to continue to disappear. What I have, in the end, what I have the most angst about is not some of the is really around the feeling that as we are talking about striving towards a more unified delivery of health care, that this bill feels to me like we're actually creating more fragmentation. And it does that because whether the medical board is the appropriate entity to oversee nurse practitioners and primary care physicians isn't the question to me, or isn't the issue to me. It's the issue is that as you transition nurse practitioners to primary care providers, you cannot deny that you are now practicing medicine independently. I don't believe anybody will deny that at this point. So to have oversight from different entities that are overseeing the practice of medicine is problematic to me. So is the medical board the issue? Is that the place where it should go? I don't know. Maybe there should be, I can't believe we want to expand government more, but, well, I can because we do.
You're a Democrat.
Because I'm a Democrat, right? Yeah, thanks. Appreciate that, Mr. Bloom. Thank you. But the reality is, I am more uncomfortable. I'm less concerned about the actual entity that supervises it, and more concerned about the concept that a single entity supervises nurse practitioners and primary care physicians. That's a big deal to me. So, will this increase access? I don't know. I have my doubts in some ways. How do we get people to where we need them? We have a maldistribution of physicians and dentists and nurse practitioners all over the state. And how do we actually get them there? And part of that may be, some sort of an exemption for rural hospitals or rural something, because I don't believe that the system as it exists now will actually allow us to increase the access. And I'm a big believer in team-based settings. I practiced for 27 years in a team-based setting. I gave a lot of latitude to my staff to be able to practice to the fullest extent of their capabilities. And it worked really well because of that team-based setting. And so I get concerned that without that, with the loss of the potential of agreed upon practices and protocols, I'm concerned that some people may actually not know what they don't know. And that interaction between professionals is a big deal. And some people may disagree with me on that, and I get that. I get that. But at the end of the day, I believe that we really need to be focusing on a way that we have supervision, not necessarily supervision, but oversight in a combined structure of some sort that allows us to do that. I also was struck by the thought that there would be potentially no fiscal impact. So if the argument is for expansion of care and the delivery of more care, how does that not impact the state in some way as far as more Medi-Cal and Deni-Cal dollars being, not Deni-Cal, but Medi-Cal dollars being spent? How is that fiscal impact only $75,000? Maybe somebody can answer that question for me? Because if our goal is to increase access and get more care to people, you can't do that without spending money. So I would love to hear an answer to that.
Did you want to?
Well, a couple things. So first of all, to your comments and concerns about the bill allowing nurse practitioners to set up independent practices, to be clear, the bill does not allow that. The model that's been adopted in all the other states allows that, but this bill is more incremental, and it says that nurse practitioners who have a national certification can work without physician supervision in a very specific list of settings in the bill: clinics, hospitals, medical groups. And we believe that those are all settings where they're going to collaborate with their peers, they're going to have that cross communication, and other professionals are going to be there.
If we can, sorry, Dr. Wood. Sorry. Dr. Wood asked a specific question. Sure. If we can have the witnesses address the question that was asked.
So I think what you're referring to is the Senate Appropriations Committee fiscal impact on the bill. It's my understanding, I don't want to speak for the consultant who wrote it, but it's my understanding that what they look at is the cost to the state to implement the bill. So the cost to the Board of Registered Nursing to implement this bill should it be enacted. That's their criteria, and that's what they looked at.
I would guess I don't understand the fiscal analysis, because I would imagine that if we're expanding care and we're treating more people by the change in this model, that there is going to be more cost to the state ultimately. So I guess for the sake of the Business and Profession Committee or whatever, maybe that implementation costs are there. But when you're talking about global costs, I have a hard time believing that analysis. So maybe
Dr. Wood,
I'm new. Sorry. So
that's okay. If I can jump in here on the fiscal debate, it does go to, if it passes out of here, it does go to approps. Mm-hmm. So that might be the proper place to bring up the fiscal questions. Ms. Baker.
Thank you. Okay, I have a couple of questions. I'm going to try to be brief. The first goes to some of the testimony that we heard from one of the proponent witnesses, and I'll direct it to Senator Hernandez or Assemblymember Eggman rather than bring her up unless you think it's necessary for her to answer it, and that was the elbow example that we got. Mm-hmm. And because as we step back, the whole point of this, as I understand, at least that I'm looking for, is that access to care would actually be increased. And I don't know why that elbow example can't just be fixed by the scope of standard protocols with the supervising physician, including it. And so is that correct, that that's something that you can just address that by the agreement that the physician has with the NP?
Perhaps I can have the individual who made the comment kind of clarify.
Well, I think the answer would be yes.
Okay.
Yeah. Let's not.
I did want to clarify that one because it was cited as an example for the need for this bill.
Yeah.
In addition, I'm also trying to understand if there was some way, basically this. As a consumer of nurse practitioners, when I call the pediatric practice for my kids or my own doctors, part of the reason that works is I know there is a doctor behind that NP that has looked at this particular individual's qualifications and decided for this practice and this patient population that's served by that, office that this particular NP is appropriate to do these particular things. And so I find more comfort that there is still that relationship. I should know better than to draw an analogy between doctors and lawyers. But for example, when I'm deciding which attorney to staff on a case, and my client is wanting to make sure that they get the right person for it, and it's at the right billing structure for what the task is, I know better what an associate is capable of. And so I feel there is an analogy there, and that it's something that's just important. That's more of a comment. The question is, I'm seeing in the letter from the California Association of Nurse Practitioners a statement that makes me think that, this much of what nurse practitioners do is already available to Californians. So seeing a big expansion of access isn't there. And it's a statement that the services encompassed in the bill are widely accepted as the range of services that Californians already receive from NPs. So I echo all the points that my colleagues have previously made, but I'm not seeing how this actually, given that the document between the doctor and the NP governs what protocols can happen, that this is going to really expand care, which would be the goal, I would think. I suppose that's a comment. I want to get that out there because I think it's important to see that I'm not sure we're there yet in the ability to expand scope. Happy to have you address it.
So the point of my story was actually something that I think will address your question as well as Assemblymember Wood's question. The point of my story was that, sure, I could get the standardized procedures updated. How difficult would that be? Pretty difficult, because having those meetings with my providers, the docs that I work with, and the administration to rewrite those standardized procedures takes months and months. So sure, could I do it? Absolutely. My point was, if I didn't have standardized procedures, I knew how to do that drainage of that elbow. I could have kept him out of the emergency department. That's where you get your savings. Yes, we will see an expansion of care. Absolutely. But you'll see savings because you won't see patients trotting to the emergency department like they do every single day. It's a misuse of the health care in this country that our patients are using the emergency departments for primary care. It's unacceptable. I'm available. I can absolutely take care of these patients' basic needs, and I'm not able to for silly reasons like standardized procedures. So,
all right, another question by Mr. Dodd.
Yeah, this has been difficult. I came in here just like, okay, it's almost like whoever I hear last, I'm voting with. I'm just,
I want to close permission to go last.
I've got a point to make.
Just kidding.
Permission to go last.
Just kidding. But I think that shows you. I'm just kidding, really. But I think that just shows you the, the complexity of this, and also maybe even the complexity of the laws that have come before us. And I'm really interested in this bar of corporate practice. And I'm of the understanding that started out, way back when corporations were hiring doctors and they were doing localized treatments. And I'm just wondering, to the senator's point, if maybe that in itself has evolved to the point where maybe it doesn't really make a lot of sense at all. And so what we're doing here is we're going around. There are other issues, but this one seems to really be a big issue. And I heard a lot of people come and testify that, I will support this bill, but I won't if these, exemptions are not exemptions, these...
It's a corporate bar.
Right. Is put in place. And I kind of even want to ask the question, but as we've evolved today in medical practice, why the corporate bar for a hospital, for example? And we heard testimony today that is a real small number that we're really arguing about anyway. But we have insurance companies that are mandating to physicians every single day. And isn't that all about profit and trying to not stop physicians, but I think you get my point. And so I think that's kind of evolved. I'm really interested in also, there was a comment made, there is no shortage of primary care physicians. I don't buy that at all. I see it every single day. I've seen it even in my own health care since I've been up here, actually. And So I think the access to care issue, to me, is really, really strong, particularly in the same rural areas in rural Northern California. We're seeing that all over the place. So I am kind of struck a little bit also by Assemblymember Wood's concern about which board should take care of it. But I think that can evolve as well. And I think that I think that I'm not sure. Let me just ask you as a question. Why do you see as a problem if we start out with the way this bill is presented?
Yeah.
Why do you see that as a problem? That if there is a problem, why can't it be modified later?
So I would like to address your question about whether or not the corporate bar is needed today. I think there's a company, Primready. The Prime Hospitals are a perfect example. There are numerous lawsuits currently underway and recently that have been filed by medical staffs against the administration and the CEO of that particular hospital chain, specifically for interfering with the medical decisions of the clinical decisions of the medical staff. And I could go into all the different particulars of them, but for instance, in one instance, it's the use of a fixed-wing aircraft to transport emergency room patients from one hospital to another. The medical staff wanted to use a helicopter to do this, but the administration, the CEO, because they had a arrangement with another business to use a fixed-wing craft, which made it much more difficult and much more potentially harmful to the patient, where you're having, for a helicopter, you can fly from rooftop to rooftop. With a fixed-wing craft, it's a much more involved thing to get a patient on a fixed wing, land, and take off. The medical staff wanted to use the helicopter, but the CEO insisted and tried to impose these new impose rules on the medical staff to use the fixed-wing aircraft because they already had a prior and were getting kickbacks from the owner of that company. So that's just one example, but there are many lawsuits and numerous lawsuits out today where the profit motive continues to be an issue in the clinical decisions and to try and impose or interrupt the autonomy of the physician and in clinical decisions.
To answer that and to follow up, I want you to understand that this individual, Primready, is a physician who has bought hospitals and has done this egregious act, but that just goes to show you that there is a for-profit amongst a physician. I mean, bottom line, we have bad actors in this world. I get it, but I don't think this is going to solve the problem of the Primreadys of the world.
And if I could just add to that as well, because I think the issue of the corporate bar, again, we only have it in 5 states, and there's no evidence that says that there are better patient outcomes and protections in states that have this than don't. Right? So we have something that we're holding out as a standard of patient protection that there's really no evidence to suggest the outcomes are different than in states that don't have the corporate bar. I mean, so there is that issue. Right, and nowhere does it apply to nurse practitioners. And again, we've all looked at the research that says outcomes for patient protection are not compromised under a nurse practitioner who does not have this level of oversight. So it seems to me a lot of this argument is around in stating something that everybody sort of agrees may not really work anymore. I don't know about you, but some of my hospitals, when I was first running, I said, what can we do? Because the physician shortage, get rid of the corporate ban. We need to if we can do that, we'll be able to do a better job recruiting, getting people in. So we're talking about a structure that there's no big evidence that I've seen that says it provides a higher level of patient protection.